Thank you, Mr. Chairman. Thanks for your testimony, Mr. Horowitz. It's been a busy week for you this week. And I'd like to turn to the question of how many emails were exchanged on the unsecured server between Hillary Rodham Clinton and President Barack Obama.
I don't know the exact number. We can go back and look. We understood he was one of 13 individuals in that.
Do you have any sense of the volume that was exchanged between the Secretary of State and the President?
I can get back to you on that. I'd have to refresh my recollection on that one.
At this point, you don't have a sense of that volume.
I just don't.
And then do you have the information or a sense of were those emails secret, top secret, classified?
My recollection is, as I sit here, that they were not among the classified material, but I'm not certain of that. So I need to go back and double check that.
And I want to ask you formally that you produce those records for us. I think it's essential that this committee understand those facts surrounding that, and I'll get to that hopefully in a moment. Could you point out to us your first encounter with the replacement of the words from the statute in 793, gross negligence, with the words extreme carelessness, the first encounter with that switch?
That was back in May as the drafts were, the Comey statement, as the drafts were evolving into June.
And were the fingerprints of Peter Strzok on that exchange?
Yes.
Anyone else's fingerprints on that exchange?
I believe Ms. Page as well.
And what about James Comey? Had he
was very much in the middle of the drafting that was going on.
The three of them were in communication and drafting that, so it'd be hard to identify exactly who inserted it the first time. Is that a fair analysis?
I think we actually do have some idea of how it got changed and who put it in, but not necessarily because it was their decision as opposed to who was the sort of scribe on it as opposed to the decision maker.
I would like a little bit more information on that, too, if you could, Mr. Horowitz.
Yes.
And so while we're searching back for the genesis of extreme carelessness as a replacement for the statutory language of gross negligence, could you inform the committee here as to the genesis of the word intent as it found its way into this dialogue?
So it looks like in a variety of discussions with the team and the prosecutors, the investigative team from the FBI and the prosecutors, that the focus was on, in a significant way, there were other factors as well here, but in a significant way the focus was on the fact that the classified material that was transiting through the email server was not clearly marked as you're supposed to have it marked, with banners saying it is classified and what level it's classified at.
More clarify my question, actually the insertion of the word intent as a condition to a violation of 793, when did that word first find itself in the dialogue that you looked at?
That is in the dialogue months earlier, well before the investigation reached its conclusion.
About when would you guess that is, the months earlier?
I'd have to,
in 2016?
It's in 2016.
Not in 2015?
I'm not sure whether it went back that far, although frankly it could have, because there's some indication that early on people thought that it was unlikely to be
Mr. Horowitz,
the case.
let me assert that the evidence I'm looking at suggests that President Barack Obama spoke that word into law. And the taped program October 10th of 2015, he said Hillary Clinton was careless but not intentional. That program was aired on October 11th, CBS 60 Minutes. And I have the article printed in the New York Times. That's dated the 16th of October, the article that references the October 11th, and where it says in this article, quote, Mr. Obama said he had no impression that Mrs. Clinton had purposely tried, quote, to hide something or to squirrel away information, close quote. Continuing, in doing so, Mr. Obama spoke directly to a core component of the law used against Mr. Petraeus, intent, and said he did not think it applied in Mrs. Clinton's case. So I'm going to suggest that the President suggested that language through the open medium and spoke the word into the law, that it require intent, which shows up throughout in the following months, in particular in James Comey's July 5th, 2016 exoneration, well, let's say a summary of the prosecution / exoneration statement, 6 times that word intent. And I find it no place else. Would you have any comments on your thoughts of how that might have been the genesis might have gone back to the President of the United States on that idea?
I don't know that that was necessarily the genesis. We don't have evidence of that, but we do have in here, as you noted, references to the statements made by President Obama and by his press secretary and the concerns that those raised and the issues that, and how it was viewed and perceived by the team, by the investigative team.
My time has expired. Thank you, Mr. Horowitz. I yield back the balance.
Gentleman from Iowa yields back.